Good evening. My name is Teresa Jacobs, and I'll be moderating our election forum this evening for the Missoula League of Women Voters, as well as 3 other campus groups who are co-sponsoring this forum. All of the groups are dedicated to voter education and civic engagement, and this event is nonpartisan, and the sponsors are not endorsing either of the candidates. On behalf of all the sponsors, I'd like to welcome you all and thank you all for coming. In one sense, our forum tonight is a debate between the 2 candidates, but it is also a discussion rounded out by the addition of 2 additional expert panelists who have agreed to help us put the candidates' answers in context and to help sharpen our understanding of the issues. We hope that you find it educational and helpful. With us, we have Representative Cindy Yonkin and Justice Jim Nelson, who are both vying for seat number 5 on the Montana Supreme Court, a position that is an 8-year term that pays $95,493 a year. Ms. Yonkin was born in Nebraska, but mostly grew up in Montana. She trained as a lab assistant, earned an undergraduate degree in microbiology, was in the Peace Corps, and earned her law degree from Lewis and Clark College in 1989 before working as a lawyer, mostly in water and property rights. 5 years later, in 1994, she campaigned for a seat in the Montana legislature. In 1998, she won a seat, which she has retained since then, while increasingly taking on legislative committee responsibilities and serving as House Majority Whip during the last 2 legislative sessions. Justice Nelson grew up in Idaho, where he earned his bachelor's degree in business administration in 1966, before serving as an officer in the U.S. Army for 3 years. He then moved to Washington, D.C., where he worked at the Securities and Exchange Commission while earning his law degree in 1974. Returning to Montana, he worked as a lawyer representing a variety of clients such as ranchers, small businesses, and banks, while also serving as the county attorney for 14 years. In 1993, he was appointed to the Montana Supreme Court, where he has served since. In 2001, he served as an adjunct at the UM Law School. With us also is lawyer and adjunct law professor Betsy Griffin and political science professor Jim Lopatch, who will be providing insightful comments and questions tonight. Professor Griffin is a Montana native. She earned her undergraduate degree from Smith College in 1977 and her law degree from the University of Montana in 1981. For 2 years, she served as the law clerk for the Supreme Court Justices Daley and Gulbranson before serving as supervising attorney in the Appellate Bureau in 1989 under Attorney General Mark Roscoe, and as chief of the Appellate Bureau in 1993 under Attorney General Joe Mazurek. She has been involved in hundreds of cases before the Montana Supreme Court and now teaches Montana constitutional law and legal analysis here at the UM Law School as an adjunct professor. Professor Lopatch is a native of Great Falls. He earned his bachelor's degree at Carroll College in 1964. He earned 2 master's degrees in subsequent years at the University of Notre Dame, where in 1973 he also earned a PhD in American government and public law. His own scholarship includes authorship of 3 books and contributions of chapters and articles for numerous books and journals. He has held many positions of leadership during the last 30 years on this campus. He teaches courses such as constitutional law, judicial process in the political sciences department. Okay, so over the next 90 minutes or so, I will be asking a series of questions that have been formulated by a committee of the League of Women Voters. Some of our questions will be addressed only to the candidates, and some will be addressed to all 4 candidates. There will be a 2-minute limit for responses to the questions. Each panelist will also be invited to make follow-up comments of up to 1 minute each after most, but not all, questions. Neither candidate has been told what the questions are, but Professor Lopatch and Griffin have seen the questions, since both of them will also have the opportunity to ask a question, and we didn't want them to repeat. Candidates may not direct questions to each other, And there will be 1-minute closing statements by the candidates only, but no opening statements. Our timer tonight is John Fletcher from the League of Women Voters in the front row here. Towards the end of the forum, I will be reading written questions from the audience. So we have ushers here tonight who will provide you with paper and pencil and carry your questions to a committee that has convened out in the hallway, and they will be selecting about 6 or 7 questions. The committee charged with selecting these questions is made up of a representative from each of the co-sponsoring organizations. So now I'll let you know who all the co-sponsors are. We have Arlene Brown from the Missoula League of Women Voters, Kim Karst from Pi Sigma Alpha Political Science Honor Society, Marianne Stansberry from the Phi Delta Phi Law Student Fraternity, and Andrea Vernon from UM's Office of UM's Office for Civic Engagement. Please submit questions that both candidates can answer and that are not hostile, of course, to either. Questions will be selected on the basis of clarity and not being repetitious, and candidates will have 1 minute to answer your questions, so please keep that in mind. During the forum, we ask that the audience refrain from clapping or in any way distracting the candidates, but I do ask you to please join me now in welcoming our panelists. Good evening. As determined by a coin toss, Ms. Yonkin will be the first to answer. You will have 2 minutes. Please talk about the role of the Montana Supreme Court in terms of the service that it provides for the public, and why the public ought to care who serves as a justice on the court.
Well, the court system in our state, whether you're talking about the Montana Supreme Court or the district court, is all encompassing of the judicial branch of government. And its job is to interpret and apply the law as was made by the people of Montana in their constitution or through their elected legislators. And whenever the court goes beyond those issues, I think the people are left out of that process. It's very important to make sure that the public is involved directly in their lawmaking process, and that's why I believe that it's appropriate for the legislative branch of government to make public policy, because that's where the public has the most opportunity for input. What was the second half of your question?
Why the public ought to care who serves as a justice on the court.
Well, certainly everything that the Supreme Court does is important to individual Montanans, no matter who you are, whether you've ever been in court or not. Oftentimes people neglect to become informed about the court system because they've never been in court, to their good credit. That's the way most Montanans are. They've not found themselves in court for any reason, and it's difficult for people to know why they should care about the Supreme Court. But certainly opinions coming out of the Supreme Court affect Montanans in their everyday lives when it may come to DUI laws or insurance laws or liability laws. When it comes to all those sorts of things, it affects everyday, ordinary Montanans in whatever it is that you do in Montana, whether you're a law student or you are running a coffee shop down the street or you're a rancher in Broadus. Everything that the court does affects you in some way or another. It may be interpreting law when it comes to easements. It may be interpreting and applying the law of torts and personal injury if it comes to having a crack in the sidewalk in front of that coffee shop that I just mentioned. So it's really important for everybody to become informed about what is the law and how does it apply to them, and that's what the Supreme Court is doing all the time, is determining, interpreting those laws and figuring out how it applies in that particular situation.
Thank you. Justice Nelson, would you like me to repeat the question?
No, thank you. Thank you, Teresa. And thank you all for being here tonight. Really, the function of the Supreme Court is threefold. The first obvious thing that the Supreme Court does in its function is to interpret the law, apply the law, and settle ordinary disputes in cases that are appealed to the court or come to the court by way of original jurisdiction. There's a second function, an administrative function, and that function involves the supervision of the court system in Montana and the supervision and application of discipline to attorneys in Montana. Perhaps the most important function of the Supreme Court is to interpret the Constitution and to make sure laws that are challenged under the Constitution are in fact constitutional and do in fact comply with the constitutional mandates of not only Montana's unique Constitution, but also the Constitution of the United States of America. it's important that we elect good judges to serve on the court because obviously we want laws fairly and impartially applied and determined. We want disputes fairly and impartially settled. And probably most importantly, we want to protect our constitutional rights. We want judges on that court who are committed to the oath of office that each of us takes. And that requires only two promises. One, to support, protect, and defend the Constitution of the United States. And secondly, to support, protect, and defend the Constitution of Montana. That's our job. That's our promise. That's what we have to do. And that's why it's so important to elect good judges on the court.
Thank you. And so now it's time for our panelists to give a comment. You have 2 minutes, and it's Professor Griffin, please.
Well, I really think that at its most basic, the main duty of the Montana Supreme Court is to really settle disputes between two private parties. I think by far the bulk of its work is in settling those disputes, whether it's between two private parties, the state, and an individual. So, and these are from a broad array of cases and situations, you know, from DUIs to homicides to trespasses to contract disputes to negligence cases to insurance disputes, divorces, and family law. So our whole body of law is based on the cases, our whole body of common law is based on the cases decided by the Montana Supreme Court. And these are based on disputes between two individual parties. So you should care about who's on the court because you may be in front of the court at some time. But also the decisions that they make become part of the body of law that we study as lawyers and learn to apply as lawyers and guide our everyday actions as well, I think.
The Montana Supreme Court is a very hard-working court because it is the only appellate court in Montana. All cases that go on appeal from the state district courts go directly to the Montana Supreme Court. I believe that the workload in terms of petitions to the court for them to pick up cases has been in the neighborhood of about 700 cases a year. The U.S. Supreme Court decides about 70 cases a year. So our Montana Supreme Court works very hard as the only appellate court. In that capacity, it has final say in what the meaning of Montana law is. The United States Supreme Court would not get involved in questions that are purely of state law. It would be their say that is going to hold weight as the meaning of Montana law. Now, what we want of those our justices who serve on the Montana Supreme Court, I think, is symbolized by the universal symbol of justice, that is the figure of a woman blindfolded holding scales. And we would expect that the justices who serve us on the Montana Supreme Court are objective, are impartial, and I think because of this tremendous workload that they're vigorous, energetic, capable people.
Thank you, Professor Lepach. Question number 2 is for candidates only, with comments after by all panelists. Justice Nelson, you will be first, and you will have 2 minutes. What temperament and experience are necessary to responsibly fill the role of a Montana Supreme Court justice? And to what extent do you have both of these?
Well, the temperament that justices need, like any judge in our society, is one of fairness, impartiality, and I think a measured approach to the law. The other thing that judges need is a wide range of experience. Judges, I believe, need experience not only in litigation, but experience in all of the types of areas of the law that we deal with constantly on the Supreme Court. That includes all areas of civil law and all areas of criminal law and administrative law as well. I believe that I have demonstrated in my 11 and a half years on the court that I have the temperament to be a justice. I'm hardworking, I'm honest, And I believe I have the sort of impartiality and approach to cases and scholarship that service on the Supreme Court demands. Additionally, I have the experience both in the practice of law and in public service that enables me to be a good justice. I've had 20 years of civil law experience in Cutbank and a general practice dealing with all areas of the law. I was a county attorney for 14 years, prosecuting everything from homicides to traffic offenses, and representing the county commissioners and public officials, 3 school districts, and the local hospital and nursing home. I've served on the Oil and Gas Commission, the State Gaming Advisory Council, the Governor's Task Force on Corrections, and Criminal Justice Policy. And while on the court, I serve on probably a dozen bar and court commissions and committees, and one national committee, the National Conference of Commissioners on Uniform State Laws.
Thank you. Would you like me to repeat the question?
No, thank you. Basically with temperament and experience.
Right, and you have 2 minutes.
You know, the temperament of a judge, I think, obviously has to be very even-handed, and the ability to not become what I would characterize as unruly. Certainly in a district court level, you find that the court is oftentimes dealing with witnesses of all sorts of types. Certainly on the Supreme Court, we don't deal with witnesses. But what the Supreme Court is dealing with is simply the issues of law that come before the court and not the facts before the court. So that temperament needs to be very even-handed and very impartial, and I think that every judge needs to make a conscious decision every day to leave his or her personal beliefs at the door when you're looking at these cases so that you can apply the law fairly. That experience obviously needs to be broad, and I do have a broad base of experience. Started out doing water rights and property law, have done divorces, employer, employee, landlord, tenant, and also am city attorney for White Sulphur Springs. And so I have prosecuted misdemeanors in that court. I've appeared in every court in this state, with the exception of workers' comp court. I have done jury trials. I have been before the federal court system. And so that broad base of experience is important. And I think it's also important to have varied experience in the justices on the Montana Supreme Court. I wouldn't want to have all the justices have the same type of background, because having different life experiences and different legal experiences amongst and between all 7 of the justices on the Supreme Court, I think makes for a better court and makes for a better, broader perspective of issues that are going to come before the court, because it's impossible for every justice to have had experience in every single kind of law that comes before the court. And there are several justices that have not had a criminal experience in terms of trial work on the court. And so having a broad variety of experiences between those justices is important. And I bring a different type of perspective. I've had experience in all 3 branches of government, and I think that that's a different sort than the other candidates have.
Thank you. Now each panelist is allowed up to 1 minute for a follow-up comment. And Professor Lopatch, you are first.
Thank you. The temperament that the judge has, should have, is extremely important. And I think that one of the most important ingredients of judicial temperament is judicial restraint. That is, as much as possible, the judge should realize the difference between a legislator and a judge, and that should enter into the carrying out of the duties of a judge. One of the classics of the judicial process, Justice Benjamin Cardozo talked about restraint. I'm just going to read a very short passage to end my comments. Cardozo said, "No doubt the limits for the judge are narrower. That is, the law that a judge makes, the ability, the opportunity that the judge has to make law is far narrower than the legislator. The judge legislates only between gaps. He fills the open spaces in the law. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. He is not a knight errant, roaming at will in pursuit of his own ideal of duty or of goodness." So that, I think that's extremely important, that the judge works very hard. It might be impossible all the time, but the judge should know that and work to realize that temperament.
Thank you, Jim. Betsy?
Well, I think there are 3 qualities that you really look for in a justice and that make up judicial temperament. And they're judgment, And by that I mean good, reasoned, careful, thorough judgment based on the facts of a particular case and the legal research and precedent involved from prior cases. And the second characteristic is integrity. I don't think that can be overemphasized. That's a sense of fairness, it's independence, it's neutrality, where you're not beholden or obligated to any particular constituency or group. And the third thing that you really want to look for in a justice is knowledge. And knowledge can be gained in so many different ways, through education or through experience, but they need to have that knowledge base, and then also while they're on the court, an ability to learn.
Thank you, Professor Griffin. Justice Nelson, you have 1 minute for a follow-up response if you would like.
Well, I agree with the comments of the panelists. Integrity, knowledge, scholarship, impartiality, fairness, those are all marks of a good justice or judge on the district court, or any judge for that matter. And as I said, I believe that I hold those qualities. I've demonstrated those qualities over the last 11 years while I've been on the bench, and I think that's the sort of qualities that inure me to the voters and to serve on the Supreme Court.
Ms. Youngkin?
You know, it's nice to have a different viewpoint here from the esteemed professors here as well. And I would agree with what was said as well. And Professor Lopatch's quote from, I believe it was Benjamin Cardozo, is quite appropriate here to remember what is the role of the judiciary when you are the judge in that case, and what is it that you view your role as doing. And I think that it's critically important to remember that as a justice, my job is not to second guess what the people meant when they put something into their constitution, but to do what was intended by the people in the constitutional framers in Montana. So a judge's very important role there is to not superimpose his or her idea of what he would like the law to be, or what she thinks the law is, but rather what was the intent of the framers of that law in the Constitution, or in the ballot initiative, or in a statute that may be passed that's currently before the court.
Thank you. Question number 3 is a question from Professor Griffin to candidates only, who will also have 1 minute for a follow-up comment.
Okay. The impartiality, that's a word we've been talking about a lot tonight. The impartiality and independence of our judiciary is always a concern. In the Minnesota versus White decision, the U.S. Supreme Court held that the Minnesota canon of judicial ethics that precluded a judicial candidate from quote, announcing his or her views on disputed legal or political issues was a violation of free speech. Do you agree with this decision? And if your answer is yes, how do you reconcile the apparent conflict between announcing a position during your candidacy and then acting impartially on the matter if it is before you as a justice?
Ms. Youngkin, you are first. You have 2 minutes.
Well, whether I agree with the opinion or not, it is the law of the land. It was a United States Supreme Court opinion that was issued a couple of years ago, and it does allow judicial candidates to express their personal opinions. I think that a judicial candidate needs to be extremely careful if he or she should decide to do that. Because if you have already made up your mind where you are on a particular issue and how you might rule on it, then you've compromised your ability to rule on something with the greatest impartiality that the parties deserve to have. So I have been extremely careful about that. Certainly as a legislator, I have a voting record on an extremely wide variety. In 3 legislative sessions, I've probably cast ballots on several thousand bills. And if people want to look at my public record, then they're free to do so. But that does not mean that that's necessarily how I would rule on a particular issue if it were to become before the court. A judge has to wait and see what is the issue, the specific issue that comes before the court, how has it been framed, what are the arguments of the parties, and what is the applicable law to that situation before he or she can fairly and impartially make a decision based on that. So while White versus Minnesota, or whatever the name of the case was, I get it backwards, may have said that a judge can do that. If he or she is willing to say, this is how I would rule on that issue, then I think that that particular justice would have to recuse him or herself from that particular case when it came up. And such was the case, as my opponent pointed out earlier today, with Justice Scalia on the Pledge of Allegiance case. So for that reason, I'm not willing to tell you how I would rule on some particular issue. And if people ask me about that, that's usually what I will tell them, is that I have to wait, reserve judgment until I see what is the issue before the court, what are the arguments of the parties, and what is the applicable law to that before a decision can be made. Because the first and foremost thing that every justice needs to do is keep the impartiality and make sure that everybody has a level playing field.
Thank you. Justice Nelson, you have 2 minutes.
I don't agree with the Minnesota Republican Party versus White case. And I recognize that while it's the law of the land, what the case does is allow judicial candidates to voice their personal opinions on issues that may come before the court without promising what they would do. But the decision does not require that. I'm maybe from the old school that I believe that it's unethical to give your opinions on issues that may come before the court in advance of the decision. And I think it's improper for a couple of reasons. First of all, what candidates will tell you, and in fact at the start of this campaign, Judge Ed McLean and I were the only ones that held to this view, incidentally. But what candidates will tell you is that, well, I'll tell you what I think now, but when the decision actually comes before the court, or the case comes before the court, then of course all that goes out the window. I'm going to be impartial and decide simply on the case. And I guess that begs the question, if my personal opinion is not relevant when I actually have to decide the case, why is it relevant before I decide the case? The second issue is, as Ms. Youngkin pointed out, I believe that any judge or justice who voices an opinion on a case, issue that may come before the court, before it actually does come before the court, is duty-bound to recuse him or herself from the case. And I think that's important. The voters in Montana elect our justices to decide cases, not to have to recuse themselves when the actual hard question comes before the court.
Ms. Youngkin, you have 1 minute for a follow-up comment, if you'd like.
Well, I think it's important to remember really what is the judge's job. As I said earlier, it's not a judge's job to decide if a law is right or good public policy. That's the people's job to decide what that public policy should be. And what my idea, or how I may have voted if I were in the legislature, or how I voted on a ballot initiative in the ballot box, I mean, I get to vote just like everybody else does, is not what it should be the basis of an opinion. The basis of that opinion should be, what is the law, what does the Constitution say about it, and how does it apply in the end? And it is important for those personal opinions to not cloud your judgment, because it's very easy to allow that to happen. And that's why it's so important at all times to remember, what is your job as a judge? Is it to superimpose your idea of what you want the law to be, or is it to follow the law and the Constitution? And I believe it's the latter, to follow the law and the Constitution. And so keeping those personal opinions out of the mix is important.
Justice Nelson, you have 1 minute if you'd like to follow up.
Well, I think I've said all I want to say about the Minnesota Republican Party versus White case. As I say, it is the law of the land. I choose not to follow it, which is my right, and I think that it's totally improper for judges to give personal opinions to the public on views that are on cases that may come before the court. We were asked earlier today our opinion on some of the various initiatives that were being voted in Montana, some very controversial. And I declined to give my opinion on those, and will continue to do so in the future.
Thank you. Before we move to the next question, I want to let the audience know that we will be collecting all written questions from the audience that you would like to have submitted to the committee. We'll be selecting them after this next question. Question number 4 is addressed to the whole panel. Justice Nelson, you'll have 2 minutes to answer first, and this is the question. Our Montana Constitution is unique in its strong defense of human rights, such as the right to privacy, to a clean and healthful environment, to open meetings, and to bear arms. As a Supreme Court Justice sworn to uphold the Constitution, how would you support the intent of the Constitution to protect the rights of everyone, including those in the minority, especially when the Constitution itself can be amended by a majority vote of the people?
Well, and that touches on the exact issue that I just talked about, and I'm sure that we're talking about I-96, the anti-gay marriage amendment. Teresa, you're correct. Our Montana Constitution is unique. It does protect a bevy of individual rights, including the right of privacy, the right to a clean and healthful environment, the right to human dignity, and the right of open government, the right to know. When the Constitution is amended, if it's amended, if it's challenged in court, then it will be the obligation of the court, as we do with any challenge that comes before the court, to read the briefs, to look at the law, to look at the Constitution, probably to hear oral argument, and to make some decision that's appropriate under those circumstances. Sometimes it's necessary to weigh one constitutional right against another. We very often weigh, for example, the right of individual privacy against the right to know. And I assume that that same process would take place in future cases. It's simply the process we go through without making up our mind ahead of time, and that's the process that we would follow, I assume, if any challenge were brought under the Constitution.
Thank you. Ms. Youngkin, you have 2 minutes.
The Montana Constitution does have a long list of inalienable rights, which is different than the United States Constitution as well as most other state constitutions. It's the court's job on all levels to balance those competing interests of a party. That's what's at the basis of every lawsuit, is there are competing interests that are happening. And sometimes there are competing constitutional rights at the basis of a lawsuit. So the court does have to balance those rights to determine which one is going to be the successful one in some particular situation. There are the rights to own property, and there are individual rights, as well as the one most commonly balanced is the public's right to know, as Justice Nelson stated, with individual privacy. So when you have publicly funded institutions, does everything that happens there become public information? Well, if it's a school, are school records open to the public? Probably not. How about medical records? There again, it may be a publicly funded institution, but the individual right to privacy is probably going to outweigh that. We do have the unique opportunity here in Montana, unlike a lot of eastern states, where the people of Montana can amend their own constitution, either by petition or by referendum from the legislature. And that is the people's right to do so. They can repeal the entire Constitution and start over if they want to, or they can repeal certain parts or amend certain parts. And it is the people's Constitution, and there are possibilities that a constitutional amendment could be in conflict with some other part of the Constitution, and that is a question that very well could find its way before the Supreme Court to decide if a constitutional amendment is unconstitutional. I think that would be an interesting argument to see, and it may very well come up in the following months. But it is an important thing that we do have here in Montana, that the people have the ability to amend their own constitution at the people's will by putting matters on the ballot that they see appropriate, and if it's not the will of the people to pass a ballot initiative, then it won't happen. But it is important to remember that the Constitution is there to protect the minority.
Professor Griffin, you have 2 minutes.
Well, I do think that one of the most interesting questions is when 2 constitutional provisions conflict. And what does the court do when it has that? And the balancing test is frequently what the court uses. That's correct. But we do have a series of fundamental rights in Montana, and those series of fundamental rights have been construed by the court to require a compelling state interest to supersede or to justify a violation of those fundamental rights. And what will be interesting to see is what type of balancing test is actually applied when or if a constitutional initiative is passed that is in conflict with those fundamental rights, and whether or not the constitutional initiative itself grants or takes away those fundamental rights.
Thank you. Professor Lopatch?
The perennial question going all the way back to the beginning of our country has to do with the nature of the Constitution. How permanent is it? How easily should it be changed? Jefferson argued that a Constitution should change every 20 years, every generation, that each generation should be able to adopt its own fundamental values, write it in the Constitution. So I agree that we should not be adverse at all to the people's right to alter their document, to change the Constitution. On the other hand, what we should really be wary about would be a judge who is, according to his or her own values, are trying to update the Constitution. I feel much better that the amendment process is used to update the Constitution and not the judge's values. I would be opposed, for example, to the famous Professor Lawrence Tribe of Harvard Law School, who wrote the very generality of many of the terms the framers used, such as liberty, due process, and equal protection, and these, of course, are all found in our own Constitution, strongly suggests an intent to invite judges to develop meanings in light of the needs and insights of succeeding generations. I would think the amendment process would be the way we update our Constitution, not through interpretation.
Thank you. And Justice Nelson, you have a 1 minute comment if you'd like.
There's an interesting provision in Montana's Constitution that most people don't know much about. It's Article 2, Section 34 of the Constitution, and it reads, unenumerated rights. The enumeration in this Constitution of certain rights shall not be construed to deny, impair, or disparage others retained by the people. The interesting thing about this provision in the Constitution, when it was enacted by the framers' intention, is specified in the Con transcripts, was that the Supreme Court of Montana would be the institution which would expand people's civil liberties. That's actually in the Con transcripts, and it's something that was contemplated by the framers. Thank you.
Thank you. Ms. Youngkin, you have 1 minute.
Now, another interesting provision in the Montana Constitution is that it is reviewed every 20 years by the people of Montana, and it will be up again for review by the people on your ballot in 2012, I believe. And that was an interesting provision that our constitutional framers did put in there. I think that it is important that the people amend their Constitution rather than the courts amending the Constitution. A lot of constitutional provisions are not self-implementing. They, in fact, specifically say that they should be implemented by the legislature because they tend to involve more complicated issues and require more public input into what is necessary in order to implement certain provisions of the Constitution. Some of them are self-implementing, like your right to free speech is rarely the subject of interpretation. You either have it or you don't, and sometimes free expression may be subject to interpretation, but most of the time it's fairly straightforward and self-implementing. But those provisions that require greater public input need to have the greater public input in order to implement them.
Professor Griffin, do you have any more comment?
I have no further comment.
Okay, and Mr. Lopez?
Yeah, I'd like to say the passage quoted by Judge Nelson is identical to the 9th Amendment in the United States Constitution, and only one justice of the United States Supreme Court ever attempted to interpret it. It was Justice Goldberg, and it never went over with the rest of the court. I think the best interpretation of such a passage is that certainly the people retain those rights, and it should be the people who place new rights in the Constitution through the amendment process.
Okay, thank you. This is now a good time if the audience could pass any questions that you haven't already given to the ushers. We would like to have your questions submitted now. Thank you. Question number 5 is for candidates only, with comments after by all the panelists. I'm sorry, that was a mistake. Yes, it is by all the panelists, excuse me. So, Ms. Youngkin, you will have 2 minutes to answer. Strong charges and counter charges have emerged in the public debate between yourselves during this campaign. Please repeat for us the charge most often made by your opponent or others, and give us your best rebuttal to those charges. As a courtesy, please define terms that are not commonly understood.
Just for clarification, the question is the charge most often made against me by my opponent
Or others?
or others?
And give us your best rebuttal.
I would suggest it's probably that charge that I don't have any legal experience. I was actually, someone said that to me, you don't have any legal experience, do you? I said, well, I've been practicing law in Bozeman for 15 years. I don't know what you think I've been doing over there, but I've been a zealous advocate for my clients for those 15 years. And I do have a wide variety of experience. And the way that you overcome that in the rebuttal is with the facts. The fact is, as I stated earlier, I have appeared in every court in this state with the exception of the Workers' Comp Court. On every level, I've had jury trials involving civil matters as well as criminal matters, and I've also appeared in the federal court system. I've also had the experience of being in the executive branch of government as an appointee to an executive board, and that was the Montana Board of Environmental Review, to which Governor Roscoe appointed me in 1995, which I chaired for 3 years. It gave me a completely different perspective, I think, than anyone else on the court, and that perspective is, what is the appropriate role of the executive branch of government? What is the appropriate role of the legislative branch of government? And what is the appropriate role of the judicial branch of government? And having experience in all three of those branches, as well as a wide variety of matters in my law practice, I think tells you that I have the experience. Some say you don't have enough courtroom experience. Well, there's other justices on the Supreme Court that hadn't had any experience in the courtroom at all before they went on the court. So it really is a matter of what you have done, and not necessarily have you done everything or have you spent your entire career doing one area of the law. And as I said earlier, it's important to have a wide variety of experience between all 7 justices on the Supreme Court. I do have the experience, I do have the temperament, and apparently my clients believe that I have the integrity and the honesty that go along with that, because they keep coming back. I have an extremely busy law practice that I'm giving up in order to go and serve all of the people of Montana on the Montana Supreme Court. So that's my best rebuttal, is what is the facts of the situation, and I'd ask you to check my record.
Thank you. Justice Nelson?
Well, the charge that's most frequently made against me and the rest of the court is the charge of judicial activism. My opponent has framed that in 2 respects. First, she claims that we overrule too many cases, and she based that charge on a law review article written by Professor Jeff Rentz. The law review article was not about judicial activism, it was about stare decisis. And of course, Professor Rentz and Professor Eilson completely rejected my opponent's interpretation of that article a couple of weeks ago in a public forum in a press conference. The other way that charge is made is dredging up, cherry-picking some of the cases that the court has handed down or that I've written over the past 10 years. And I would submit to you that if you actually read those cases and read what the court said in context, what you're going to find is that the court's decision was well-reasoned, that it was well thought out, it was well cited, it was authoritative, and in most cases has been misrepresented by my opponent. Judicial activism really is bringing your own personal agenda or party politics or partisan agenda to the bench. That's what judicial activism is all about. This is a charge made by politicians as part of an election year tactic to scare voters. It sounds good. And it's really designed to destroy the independence of the judiciary and to elect judges who are simply rubber stamps for the other 2 branches of government, or just as bad, rubber stamps for special interest groups.
Thank you. Now, Professor Lopatch, you have 1 minute for comment.
The charge that I have heard the most is activism. When I read the newspaper articles about the race, that seems always to come up. One or the other is activist. One says that I won't be activist. What I want to say is that some activism is inevitable. It just is absolutely necessary for judges to interpret the Constitution when they have a case before them. They are going to have to interpret the Constitution. The problem is the degree of activism. For example, Justice William O. Douglas said that his own personal jurisprudence as a judge was that those least favored in life should be most favored in the law. Well, that seems like you're going into cases with a certain bias, and you want to write that into the law. I would say that that would be not the right kind or not the defensible kind of activism. But judges do have to interpret the law. Inevitably, their values are somehow going to find their way into the law. The problem is they should be aware of it and try to restrain themselves.
Thank you. Professor Griffin?
I think the charge I've heard most frequently too is one of judicial activism, and I have to say I too am kind of frustrated with that term. Under our system of government, as I mentioned earlier, judges do make the law. That is what they do. Even Justice Scalia in the U.S. Supreme Court has recognized that when a judge or appellate court issues its decision, that becomes a body of the common law on which we then base precedent, and new law evolves. And the duty of an obligation of justices is to fairly decide those cases in front of them. But sometimes there is a conflict with the prior precedents. And at that time, they also have a duty to reconcile those conflicts. And I think when through that process of reconciliation, you do see new law made, and sometimes you see this broad term of judicial activism used. The Constitution, in Montana is a broad document, and it requires interpretation. It is the position of the justice to be able to interpret the Constitution and give meaning to it when specific facts are brought to them. Thanks.
Thank you. Ms. Youngkin, you have 1 minute.
I'd like to give you the Black's Law Dictionary definition of judicial activism. Quote, judicial philosophy which motivates judges to depart from strict adherence to judicial precedent in favor of progressive and new social policies which are not always consistent with the restraint expected of appellate judges. Is commonly marked by decisions calling for social engineering, and occasionally these decisions represent intrusions into legislative and executive matters. I would also encourage everybody to get their own copy of the Montana Law Review article entitled Stare Decisis and read it for yourself. And I'll read from you something here, quote, beginning in 1970, the court's rate of overruling precedent increased geometrically as it doubled, redoubled, and redoubled again during each succeeding decade. This gives rise to one conclusion: the current court has been the most active in Montana's history. It has been rewriting law at an unprecedented rate. So based on dictionary definition, exact quotes, I'll let you draw your own conclusions, and would ask everybody to get this and take a look at it yourself. It's not written in heavy legalese. Anybody can pick it up and read it and come to your own conclusions.
Justice Nelson?
Of course, Black's Law Dictionary doesn't refer to stare decisis, which is what Jeff Wren's article was all about. And Jeff Wren's article doesn't refer to activism. There is a difference between a court being active and a court being activist. An active court is one which diligently protects, supports, and defends the constitutional rights that we as citizens enjoy. That's our job. That's the oath that we take as judges. That's not being activist. And if I'm accused of being an active judge, so be it. That's what I've done for 11 years. That's what I'm going to do for the next 8.
Ms. Young, would you like 30 more seconds, or should we go on? We could do one more round for candidates of 30 seconds each, if you don't feel like you've finished with this one, or we could go on. Let's move on. Okay, let's move on. Justice Nelson? Okay. Question number 6 is a question from Professor Lopatch to candidates only. Justice Nelson, you will answer first, and you have 2 minutes.
Judge Nelson said earlier that this was the last thing you were going to say about the White case, the Republican Party of Minnesota versus White. But I'm going to give you another chance to say something about that case from a different angle.
Okay.
Justice Sandra Day O'Connor wrote a concurring opinion. She was a Supreme Court justice in the state of Arizona earlier in her career, and she knows something about selection of judges. She wrote, elected judges cannot help being aware that if the public is not satisfied with the outcome of a particular case, it could hurt their re-election prospects. Relying on campaign donations may leave judges feeling indebted to certain parties or interest groups. If the state of Minnesota has a problem with judicial impartiality, it is largely one the state brought upon itself by continuing the practice of electing judges. So she's implying that elected judges cannot be impartial. almost inherently. It's a pretty strong statement that she made. So I have two questions for each of the candidates. The first is, do you agree or disagree with her? And secondly, isn't it the time come for the state of Montana to considering selecting our judges by an appointed merit system, so the kinds of skills and temperaments that we've been talking about could get proper consideration?
Well, Professor Lopatch, and I know you've read that decision several times, as have I, and I think that running through the entire decision is a thread that the U.S. Supreme Court and perhaps the federal judiciary does not approve of elected judges. They simply don't like elected judges. And I guess if you think that that appointing judges, as does the federal judiciary, will take the politics out of judicial races or appointments, think again. There's probably no more political process, and you can watch it on TV, than appointing a federal judge. In terms of the issue of candidates being beholden to people who contribute to campaigns, the campaign limits in Montana are $250 per individual. We cannot accept corporate contributions or business contributions, and I can tell you that I have raised a heck of a lot of money on a lot less than $250 contributions, and I don't feel beholden to anybody. Montanans want to elect their judges. And unfortunately, or fortunately, I don't know, for the media, I guess it's very fortunate, judicial elections are very, very expensive. And we have to raise that money. And I don't know of any judicial candidate that feels beholden to some group or some individual because of a $250 contribution, or more likely a $50 or a $35 or a $25 contribution. I guess, Professor Lopatch, I don't agree with the white opinion on that either. I think that electing judges is just as good a process as appointing judges. I think, unfortunately, this race has got somewhat nasty, but I wouldn't throw out the baby with the bathwater.
Ms. Yelkin?
It's a great question, and it's a question that has come up well on the campaign trail. A lot of people have suggested that we should elect judges. And in this matter, I agree with my opponent that I think that having elected judges in Montana certainly is the way that our constitutional framers made it. So if we were to change that to have appointed judges, it would require all of you to amend the Constitution of Montana. And certainly, I absolutely agree that having appointed judges on the federal level does not eliminate the politics, because it is a very partisan process, confirmation by the United States Senate of the federal judges, and it's a pretty political thing. There are litmus tests there. There are litmus tests in this race as well that all of you are applying in your decisions as to who you're going to vote for. So I think that it's perhaps fooling ourselves to think that if we had appointed judges that we would eliminate the politics in our races. And I personally would like to remain accountable to the people of Montana, to whom I have been accountable in 3 elections now, rather than a small select group that may be deciding. And I also absolutely agree that there is not a candidate running for the Montana Supreme Court whose vote can be bought for $250. All of us are, I believe the other 4 candidates and myself are people of integrity, and I absolutely do not see anybody here being beholden because of a contribution of $250. And that limit is stringent. It makes it difficult to raise the money necessary, but that's what we do. I've had it suggested that perhaps we should have publicly funded judicial campaigns, and I think that's something that maybe we should consider. Don't know if there's the legislative will to do that, but if there were publicly funded judicial campaigns and the candidate couldn't put in their own money, which has a whole nother discussion about that, it would take away any appearance of impropriety by attorneys practicing before the court, or someone with a particular organization contributing, or those attorneys contributing, and something I think that we should explore in the future.
Thank you. And Justice Nelson, you have 1 minute for a follow-up comment if you wish.
Well, the problem with publicly funded campaigns is twofold. First of all, you know, the Montana taxpayer is being bled dry as it is just to fund programs that need to be funded. I don't know that the taxpayers, I know that Ms. Youngkin and I have each probably have or will spend well over $100,000 in just media in this campaign. And I would kind of hate to go to the voters with the proposition that we've got 5 or 6 judicial candidates. You're going to have to come up taxpayers with that kind of money. Secondly, it doesn't eliminate the fact that wealthy candidates can still put their own money into these races. So if you're wealthy, if you got a lot of money to drop into a race, then you've got the money advantage right off the top.
Thank you. Ms. Youngkin?
Well, certainly, as I said, there would be a lot of things that would have to be fleshed out if we had publicly funded campaigns. One of those would be if you were willing to accept the public funds, you could not use your own money. You're welcome to use your own money if you want to, but then you couldn't use the public funds. And there are a lot of details that go along with that. It could also be something that is funded through the State Bar Association. There's a variety of mechanisms, and certainly if the candidates are not having to go out and raise money, I mean, we spend a lot of money to make money, to spend on the media that we are buying, and if you didn't have to spend that much money to go out and ask people and do fundraisers and mailers and solicitations and those sort of things, the amount that you would need for a campaign would be significantly lower. I'm not saying it's the best idea in the world. I'm just saying that it's something that perhaps we should consider and see what the public thinks about that. Yes, our legislature is battling all the time with the limited tax resources that we have, but it's something I think that we should just have the discussion about and see if it is a feasible option.
Thank you. All right, question number 7 is for all panelists without any follow-up comments. Ms. Youngkin, you'll have the first shot at it, and you'll have 2 minutes. Please talk about the need for Supreme Court justices to uphold the law with blind justice, apart from any personal beliefs or interests. And candidates specifically, how does your service in the public sector and even your campaign for seat number 5 on the Supreme Court exemplify the kind of personal integrity required of a Supreme Court justice?
Well, first and foremost, every justice needs to be willing to leave his or her personal beliefs at the door and to put on that blindfold. It shouldn't matter what the name of a party is. It shouldn't matter how much money they have. It shouldn't matter who their attorney is. And really, their issue shouldn't matter to the judge. The judge, in any case, on the district court level or the Supreme Court level, needs to actually put on the blindfold of justice and set all those factors aside. I've heard it said by a lot of district court judges, especially because they're the ones that see the witnesses, that they make it a point not to pay attention to who the last name of the parties are, especially in smaller communities where people are very well known. So it's important to make that conscientious effort to leave your personal philosophies at the door. Certainly everybody that becomes a judge or a justice on the court was at one time an attorney. And attorneys are zealous advocates, zealous if they're a good attorney, but they're certainly advocates for whomever it is that they are working. If they're doing criminal defense work, they are a zealous advocate for the defendant. If they're doing prosecutions, they're a zealous advocate for the people of Montana. Whatever it is that they're doing, they are an advocate. And when you become a justice or a judge, you have to shed the role of advocacy. It, in my opinion, has no position on the bench. The place for advocacy in the courtroom is at the defense table and at the plaintiff's table. And that's where it should stay, because if a judge becomes an advocate for any particular position, then he or she compromises her ability to be as impartial as possible. And we are human beings, we bring all of that stuff to the court with us, but you have to make a conscientious decision that that's not going to be what is the basis of your decisions, and leave the advocacy to the attorneys representing the parties before the court. Because quite frankly, that's where it belongs. If you take on that role of advocacy as the judge, then you've compromised your ability to be impartial, and you've compromised those two parties' rights to have the greatest level of impartiality that they deserve and have a right to have.
Thank you. Justice Nelson?
Well, of course, blind justice is what all litigants expect when they come before the court, and of course it is necessary that the judges be fair and impartial. I think, unfortunately, in this day and age, that's not what the public is hearing, and it's not what some sectors of the public, especially special interest group, want. They want judges to come to the bench with an agenda. I'm pro-business, I'm pro-this, I'm anti-that. And I will tell you that when we start electing judges that are pro-this and anti-that, then we have effectively destroyed the judiciary and destroyed the independence of the judiciary. We expect judges to be fair and impartial. We expect blind justice. And I think for any justice to have the reputation of being pro this or anti that is absolutely antithetical to what we are all about in the court. You ask about how that has been reflected in my own campaign. I have consistently told the voters of this state, and I will tell you tonight, I make only one promise, and that promise is the oath that I took when I became a judge, to support, protect, and defend the Constitution of the United States and the Constitution of the state of Montana. And I disagree with my opponent. Advocacy is important on the bench. Advocacy for the law and advocacy for the Constitution. That's what we should be doing as judges. That's what I have done. That's what I will do.
Thank you. Professor Griffin, you have 2 minutes.
Well, I think one of the issues highlighted by this question is the fundamental difference in campaigning for, say, an office such as a legislative office or governor, and campaigning for a judicial office. Obviously, legislators and executive officers, they are acting on behalf of the voters, and they are representatives of the voters. They are agents of the people and elected to represent them. And constituency groups can and do influence such governmental officials. But I would agree with Justice Nelson here that judges are agents of and represent only the law. Judges are not political actors. They do not sit as representatives of particular persons, communities, businesses, or organizations. And we've talked about how judges should only act with respect to the individual facts and law of a particular case. And I think that's what blind justice really means.
Thank you. Professor Lopatch?
Judicial elections, judicial campaigns are very difficult for the voter because it's really hard for us to get the kind of information we need in order to make a rational choice. And one of these reasons is that we don't hear candidates talk about cases that have been decided, cases that might come before them, contemporary legal issues. They talk more in generalities about legal ideals. And so I think what happens is that the voters do start looking for the policy views of the judges. They don't run on a partisan basis. We don't have the party identification to help us make that choice. So I think we really do start looking for their policy leanings. And this is a real dangerous thing. I agree with everyone. This is really a dangerous thing. There's a book I recently read by Justice Antonin Scalia. It's called A Matter of Interpretation. It's about constitutional interpretation and statutory interpretation at any level. And he said, if the people come to believe that a constitution is not a text like other texts, that is, that it means not what it says or what it was understood to mean, but what it should mean in light of the evolving standards of decency that mark the progress of a maturing society, well then, he says, they will look for qualifications. The people will look for qualifications other than impartiality, judgment, and loyalty acumen in those whom they select to interpret it. More specifically, they will look for judges who agree with them, this is what Justice Nelson said, as to what the evolving standards have evolved to, who agree with them as to what the Constitution ought to be. And we're really in a dangerous situation then, because rule of law goes out the window. We have rule by this person or that person, not rule of law. And the last thing I want to say that I've certainly said several times this evening is that I think it is so important for judicial candidates and for judges themselves to realize deeply the special role they play in our society, and that to the degree possible they restrain themselves from writing their values or the values their voters wanted them to write into the law.
Thank you. We'll now move to audience questions. Candidates will have 1 minute to answer, and Professors Lopatch and Griffin will have 30 seconds each for comment if they wish. The first question is, the Montana, oh, and I'm sorry, let me indicate here, Justice Nelson, you'll be first, and you'll have 1 minute. The Montana legislature seems to be increasingly reluctant to make difficult decisions and more willing to pass the decisions on to the people through referendum or have the courts rule. The recent school funding issue is one example. Please comment on this trend.
Well, I'm not going to comment on the school funding case. We're going to hear that in oral arguments tomorrow. I think that there is somewhat of a trend to pass the hot potatoes onto the court, and that's fine if that's where the legislature wants the decision being made. And contrary to what my opponent says, the policy being made, the court will make it. I think it's unfortunate that the legislature does that, and I think it's even more unfortunate that if they do it, they then complain about the decision we make.
Well, I would agree that there are times when the legislature doesn't want to deal something because it may not be politically expedient to do so. However, I do think that when there is a matter that is a political question, that the court should say, this is a political question and the legislature needs to deal with it and put it back where it appropriately should be. And that's with the people of Montana to determine those types of questions. I do have a bit of a problem with the court filling in the gaps, so to speak, especially when it is a matter purely of public policy that's not a matter of constitutional interpretation or application. And there's oftentimes a mix of things that find themselves in one particular case where the court can answer a question that is clearly before it, and there may also be a corresponding issue that is begging for an answer, but it's not the court's role in most cases to give that answer, but rather should say that's a legislative question. It needs to be dealt with by the people of Montana through their elected legislators.
Thank you. Professor Lopatch, you have 30 seconds if you care to comment.
I think a lot of the work of the court is there because of the weakness of the legislature. I think in the state we have an unusually weak legislature. I'll say probably something that'll seem outrageous. I think we have too much representation in our state legislature. Too many positions, too small districts, too parochial views. It takes an amazing kind of political leadership to get the legislature to agree on anything and pass things. So for all of this work undone by the legislature, people will take a political issue, frame it as a legal issue, and take it to the court, and then the court is faced with it.
Thank you. Professor Griffin?
Well, I agree with Professor Lopatch there. I think what happens often is then you have the court being is faced with the problem of having to interpret very broad statutes and forced to apply the law to a fact situation that wasn't envisioned by the legislature. And that's one of the results of that is this term an active court. It has to be active because it has an obligation to resolve the dispute in front of it.
Okay, thank you. Question number 2 is, again, to candidates, and Ms. Youngkin, you will have 1 minute. What role does the court have in correcting public policy that is in conflict with individual liberties?
Well, that's something that we've already touched on a little bit, and that's when you have conflicting provisions of law. And certainly the constitutional basis needs to be overriding. If there's a statutory conflict with a constitutional provision, then that needs to be dealt with appropriately and said so. If you have two constitutional provisions that conflict with each other, perhaps a new amendment comes on and conflicts with something that's already in there, then that becomes a balancing test that the court has to go into. But when it's statutory or something, a ballot passed initiative by the people of Montana that's in conflict with the Constitution has to be followed first. And sometimes things get passed by the people or by the legislature that have constitutional problems. But we have to follow our own rules, and the basis of all those rules are in our Constitution.
Thank you. Justice Nelson, you have 1 minute.
Well, the constitutional liberties we enjoy are set forth in the Declaration of Rights in our Constitution. Those are fundamental liberties. Those are guaranteed to us. They can't be infringed. Sometimes they have to be balanced one against the other. But as I understand the question, if the legislature passes a law that infringes those, and there is not the compelling state interest to do so, then it's the obligation of the court to settle that, and I believe to rule in favor of the individual liberties. The Constitution is the organic document. It's the base document. Even the legislature can't mess with it. It can't invade the Constitution.
Thank you. Professor Griffin, do you have any comment?
Well, I agree with the candidates here. Obviously, the Constitution is the fundamental law of the state, and if there is an initiative or a referendum that conflicts with the Constitution, the court is obligated to interpret and apply those principles.
Thank you. Professor Lopatch?
The only problem I have with some of the topic that the question raises is that sometimes the court is more eager, or appears to be, not our court, but any court can appear to be eager to create a right. It's one thing to get a case that is a freedom of speech case, and the court has to ask, is nude dancing, or is pornography, or is campaign finance, or is that free speech? And they have to do it. They have to decide the case. But it's another thing to take the word liberty in the Due Process Clause and use it, as Professor Tribe says, an invitation to create totally new constitutional rights, not envisioned by the framers of the Constitution. So rights have to be protected. They are fundamental. And the tests are very strong to protect them.
Thank you. Justice Nelson, you have 1 minute to be the first to answer our next question from the audience. Many recent and far-reaching opinions of the court have relied upon Montana's right of privacy. What areas do you believe are protected generally by Montana's right of privacy? And please compare them with the areas protected under the federal Constitution.
In 1 minute?
Yeah, it's a test.
Montana enjoys a unique right of individual privacy under Article 2, Section 10 of our Constitution. I said in the Armstrong case, when I wrote the decision in that case, that the parameters of the right of individual privacy had not fully been explored. I don't think they have. We've discussed reproductive autonomy. We've discussed personal autonomy. We've discussed information privacy in various search and seizure cases. Those are just some of the areas. The federal Constitution has no textual right of privacy. And that's why Montana's is so unique and so important. The U.S. Supreme Court has found a right of privacy in the federal Constitution from a penumbra of other rights, as the Supreme Court has said. That's why it's so important that we protect Montanans' individual right of privacy. In some ways, the framers thought that was the most important right in the Declaration of Rights, the right to be left alone.
Thank you. Ms. Yonke, you have 1 minute.
You know, certainly the right of privacy is very, very important to all of Montanans. And I think that you have to remember that we do have a right of privacy, but that right of privacy cannot infringe upon another person's rights. We all have the right to raise our children the way we see fit, but you do not have the right to neglect your children or to abuse them. You don't have all-inclusive right of privacy to do whatever you want in your own home, and that's when those rights infringe upon the rights of other individuals. Those have to be balanced out because children shouldn't be abused and neglected either. And sometimes there are cases where we have to balance those competing rights of privacy. For example, as I stated earlier, as a public institution, do you have the right to know what kind of care someone is providing on an individual basis to a patient at a mental facility at Warm Springs? Probably not. So there are areas that you have to be very careful about that. Protected areas involving the right of privacy, certainly what people do in the privacy of their bedroom or in the privacy of their own person are very important, as long as it doesn't infringe upon the rights of others.
Thank you. Professor Lopatch, if you care to comment, you have 30 seconds.
This is a fascinating question because, as has been pointed out, privacy is an explicit fundamental right in the state constitution. The question, though, that I would like to cede my remaining 20 seconds to the two candidates is exactly what do you use what kind of methodology do you use to determine what is included in this word privacy?
And Professor Griffin?
Well, I was going to say that the court generally applies a fairly strict test in determining what a privacy right is. And they have adopted the CATS test on, is there an actual or subjective expectation of privacy, and then is that expectation reasonable? That generally that would be the initial test to determine whether or not a right of privacy applies, but I'd like to hear the candidates' comments on that.
Do you want 30 seconds each? It seems like it's coming.
Well, he ceded 20 seconds, so that means we get 10 seconds apiece. But you know, I think that Professor Griffin is absolutely right, is that you have to apply that test as what is expected in terms of was it reasonably expected by the person to be a private area of one's life. And the other test that I think that needs to be in there is, does it affect the rights of another person? And that's an important balancing test that needs to be weighed out in that question. Certainly the question of what should be included needs to come to the court. It's not the court's job to decide, we're going to decide all these things are within the right of privacy, but rather wait for those questions to come to determine, is it part of the inalienable right to privacy?
Judge Nelson?
I think in the Armstrong decision, we went somewhat beyond the CATS test, and we articulated some other tests in the Armstrong case, and they're too complicated to get into in 20 seconds. But the other thing I think that we need to look at, and we do look at when we interpret the right of privacy, is the Constitutional Convention discussions and debates. There were some fascinating discussions by the delegates about what that right of privacy meant. And as I said, boiling it all down to what they said, they distrusted government, you have a right to be let alone, and that's what that right of privacy was all about.
Thank you. We'll move on to our next question from the audience. This will go first to Ms. Yonkin. The Americans with Disability Act, or ADA, protects the civil rights of some of Montana's most vulnerable citizens. What experience do you have with cases involving the ADA?
Well, I have, one of my clients happens to be a developmentally disabled adults workshop. And they also have a lot of group homes in and around the Bozeman area as well, in addition to their workshop. So I have had some experience with that, particularly in their group homes, in placement where they may be trying to purchase property within the city of Bozeman, and also with the ability of some of the clients that they have, not the organization is my client, but the adults with the developmentally disabled disabilities are their clients, but challenges that they have with gaining employment and those kind of issues. And so it is usually those kind of things where people are finding it's not only necessarily an access issue, a physical access issue, but can that person do the job that they have applied for? And a lot of times there are discrimination against adults with disabilities because of their disability, when in fact they have the ability to do the job for which they are applying, and they have the support structure in order to help them be able to get to work on time and things that go along with it. So,
Justice Nelson?
When I practiced law in Gutbank as county attorney, I represented some clients, mainly in connection with compliance issues under the ADA. On the court, we have really not had many cases involving the ADA. The ADA is a federal case, or a federal statute, and of course, if there are violations of that statute, they most likely wind up in federal court. So we don't get cases involving the ADA very much on the court, and if we do, it's only a tangential reference to it.
Thank you. Professor Lopatch, do you care to comment?
As a political science professor, I've had no cases in that area.
Okay, and Professor Griffin. Okay, we'll go on to the next question. Number 5, and Justice Nelson, you'll have 1 minute. Do you think we need an intermediate appellate court? Why or why not?
The short answer is yes. Are we going to get it in the foreseeable future? The short answer is no. Montana's Supreme Court handles between 840 and 900 new cases a year now. That's up from 625 new cases a year when I went on the bench 11 years ago. Typically, states need an intermediate court when they reach around 1,000 cases a year and when the state reaches $1 million in population, or 1 million people in population. We promoted the idea of an intermediate court to the legislature a couple of sessions ago, and unfortunately, it did not pass largely because of the money it would take to start it up and keep it operating.
Okay, Ms. Youngkin?
At the present time, I do not believe that we need to have an intermediate appellate court. There was a bill before the 2001 legislature, which actually came to the Judiciary Committee first before it went on to the Appropriations Committee. And it did fail largely because of the price tag. It has a very hefty startup cost to that, and then as well as the maintaining that. The judges on that. The other problem that I had with it that was brought to my attention through a wide variety of attorneys, on both plaintiffs' attorneys and defense attorneys and anybody, was that it is one more step that they had to go through to get resolution to their client's situation. And that was a great concern to them. It cost money for them to do that. It cost their clients money, and the longer that it takes to get resolution to a problem, the more it costs. And also, you've probably heard the expression, justice delayed is justice denied, and having one more hoop to go through was a great concern to a lot of people. And I think that there may very well come a time when we should have an intermediate appellate court, but we have not reached to that point yet.
Thank you. And Professor Griffin, do you have any comment?
Well, I do. As Professor Lopatch noted, our current Supreme Court is very overburdened and very, very busy. I would recommend highly an intermediate court in order to give the Supreme Court the time and resources to be able to decide its cases carefully and thoroughly. The kind of intermediate court I would like to see is one maybe limited to type of jurisdiction, like a criminal court of appeals that would handle only those questions that are like substantial evidence, non-constitutional issues, something like that.
Thank you. And Professor Lopatch?
I just have a question, probably of Judge Nelson. It seems that we're right back where we started, that is the role of the court, and it seems that given 800 to 900 cases, that the court really can't carry out its role in terms of, I'm wondering, deliberation and oral argument and writing briefs, and it seems like maybe justice is being delayed. I'm wondering about that.
Go ahead, and both of you can respond.
Well, in some respects, that's true. We've become, I think, as efficient as we can be on the court in terms of some internal changes that we have made regarding opinions. We only hear probably less than 20 to 15% of cases on oral argument, which is unfortunate. When I started practicing law 30 years ago, we actually heard all cases were orally argued. We only hear about 15-20% of the most important cases, and those involving constitutional issues or issues of first impression.
Thank you.
Okay.
And would you like to comment, Ms. Young?
Well, the only thing I would have to say is that I've not been to the court as a justice, so dealing with that workload is something I'm not as familiar with as Justice Nelson, certainly. But I think that certainly as the caseload increases, there's only 24 hours in a day, and there's only so much time, no matter how hard each individual justice on the court works, there's only so much time that they have to devote to each of those cases. And at some point we will reach that critical mass where we will have to have that intermediate appellate court.
Okay. Question number 6 from the audience goes first to Ms. Youngkin. You've been talking about balancing fundamental rights. Please discuss how to balance right to clean and healthful environment with the right to pursue property.
That's a great question. I'm surprised it didn't come up earlier. We do have those two things, the right to own and defend your property and the right to a clean and healthful environment, are both listed in the inalienable rights section of the Montana Constitution. The clean and healthful environment provision also appears later on in the environmental section of the Constitution, and it says that it should be implemented and enforced by the Montana legislature. And it is important to keep that in mind because there's an awful lot of details that go into making environmental laws that work. Your Clean Air Act and your Clean Water Act, mining reclamation laws, there's a lot of details that go into that, and I believe that's why the constitutional framework said that it needed to be implemented. by the legislature. And you do have to balance those rights. Certainly, people have the right to do with their property as they wish, but as we all know, water runs downhill and air moves. And that's why it is important that you have to have a good Clean Water Act and Clean Air Act so that we can enforce those and protect the clean and healthful environment provision that all of you have that may not necessarily own property downwind or downwater from someone who wants to pollute on their property.
Thank you, Justice Nelson.
Well, let me clear up one thing. Article 9 does not say that the legislature should protect these things. It says in sections 1, 2, and 3 of Article 9 that the legislature shall protect the environment. Shall in the law is a mandatory term. Certainly, environmental rights have to be balanced with property rights. We have not had a case before the Supreme Court where that balancing or that weighing has become necessary. It took nearly 30 years for the first case under Article 2, Section 3 to even reach the court. That was the MEIC case. We've had one other case, the Cape France case, that's mentioned the Article 9 provisions of the Constitution. And those are the only two cases really that we've had. So it'll be interesting to see how those rights are weighed one against the other when such a case reaches the court.
Thank you. Professor Lepatch, do you have any comment? Okay, and how about Professor Griffin?
Well, I think it's interesting that the right of possessing and protecting property is frequently a right that is affected by legislative action as well as constitutional action. Everybody does possess property really at the behest of the sovereign. So it's frequently that property is regulated, and its use is regulated. So it would be interesting to see how the property rights as such do balance and stand to the right to a clean and healthful environment.
Okay. As we approach the end of our forum here, each candidate has a minute for a closing statement. And Justice Nelson, you are first. 1 minute, please.
Thank you, Teresa, and thank you all for hanging in there and listening to all of us. I appreciate that you're interested in becoming informed so that you can make a good decision November 2nd. I'm just going to say one thing. I need your vote. I need your support. I believe I'm the best candidate because I'm the candidate who, over the last 11 years, has supported, protected, and defended your rights. That's what I've done for 11 years. That's what I promise to do for the next 8. Thank you.
You know, I'm running for the court because I think that we need to have a court that will interpret and apply the law. And a court should not be or act as a super legislature to assign by judicial decree that which is not achievable by political consensus. That's the job of all of you that our forefathers gave to us in this country and in this state, and that's called self-governing powers. And it's very important for all of you to exercise your rights to self-governing powers, because when you don't, eventually you may lose them. And that's probably the very most important thing that we have in this country, is the right to dictate our own future here on an individual basis with our Constitution and through our form of government, with 3 equal but separate branches of government that provide those balances and checks that go on with that. I have the experience, I have the work ethic. I have worked very hard in my 15 years of practice in Bozeman, zealously advocating for my clients in a wide variety of areas, and I know what the rules are, I know how they apply, and I look forward to serving all of the people of Montana on the Montana Supreme Court, and I thank you for your vote.
Thank you. And on behalf of the League of Women Voters and our co-sponsors, I'd like to thank the panel for participating and to thank the audience for attending and participating. I'm sorry we didn't get to the last 3 questions. We did our best. Thank you for coming, and please join me in. There is a forum reception in the foyer sponsored by the UN President's Office. This event has been taped at KUFM and MCAT. It will air on KUFM or Montana Public Radio either this Friday at 1 o'clock or the 29th at 1. And please check the MCAT schedule or you can come talk with me. Thank you.